There have been a lot of misconceptions since yesterday with the media lawyers, we will describe as television lawyers, going on here, hearing views of what they know nothing about. Some of them have never been to court before. Some of them are the people we refer to as media lawyers. Some of them are just too media-driven for the legal profession. You begin to wonder what manners of lawyers who have time to go to a television station and radio station in the morning when his colleagues are out there in the courtroom and in the library. But be that as it may, let me say clearly that I was part of the legal team. In fact, number 2 in the hierarchy of the team of lawyers that defended our candidate and our governor in Ondo State, and of course our party, the APC. Let me make this clear. This is not the first time we're having dissecting judgments in governorship and presidential election petitions. Because our memory is very short in this climb, many people have forgotten that in 1979-80, there was a minority judgment, a judgment in the case of Awolowo against Shagari. A minority judgment remains what it is, minority judgment. It has no efficacy, it has no value. The only value a minority judgment has is for academic purpose and research. You can't even cite it as an authority. Our adjectival law and our jurisprudence doesn't allow for any efficacy to be attributed to minority judgment. And again, in 2008, a Muhammadu Buhari against Yar'Adua, of which I was present, I was privileged to be a member of the legal team representing Alhaji Atiku Abubakar against Sheikh Musa Yar'Adua. Again, we had minority judgment. The minority judgment then was delivered by eminent jurists, namely Justice Aluma Muta, who later became CJN of Nigeria, Justice Oguntade, a very prominent member of Nigerian judicial system, and of course Justice Onege, who also became Chief Justice of Nigeria. In their wisdom, the 3 of them gave mighty judgments in favor of Muhammadu Buhari. People have forgotten so soon. And that was in 2000, under this dispensation. And that doesn't stop them from being elevated. Because our judiciary has matured over the years. But and those of us in the legal profession who practice law, I'm not talking of the media lawyers now, who practice law, we know that no value, I repeat, no value is attributed or can be attributed to minority judgment. So what happened yesterday is not strange. So all the noise and hula baloo baffles one. I mean, why should anybody in his or her right senses be attaching so much importance to something that should be in the realm of the academic discourse? For those of us in the legal profession, you cannot even go to court and cite it. Having said that, let's now come to the case itself. The petitioner in the case, that is the PDP and Itayo Jegede, filed the petition in October last year. The petition was abandoned. 3/4 of the claims of the petition was abandoned. That is what, how do I mean? The claim initially was to question the election. The claim initially was that Itayo Jegede won the lawful majority votes. But having seen the futility of his action on his own, without prompting, the claim was abandoned. And he now centered his main claim on the nomination and sponsorship of Oluwarotimi Akeredolu and his deputy. Of course, we took up the matter and raised preliminary objections. Among the preliminary objections we raised were: one, that the petition was filed out of time; two, that it was a pre-election matter that should ordinarily go to the regular court and not come to the election petition tribunal, which is sui generis. And thirdly, that the people mentioned in the petition that were said to have signed the nomination paper, that is His Excellency Alhaji Malabuni and the secretary, Dr. Yanakwode, were not joined to the election petition. Of course, the tribunal heard us and upheld our preliminary objections, and of course the petition was thrown out. The tribunal went further after considering the preliminary objection. The tribunal went further. They went further to consider the case on its merit and held emphatically that His Excellency Governor Malabuni has not contravened the provision of Section 183 of the Constitution, that holding party position has not violated the provision of the Constitution, that the mere fact that you are a governor does not necessarily mean that you cannot be given an assignment by your political party. After all, you become a governor on the platform of a political party. That was the reasoning of the tribunal. The tribunal went further to consider the merit of the case. Don't forget that the merit of the case centered on nomination and sponsorship only. Now, the matter went on appeal. Of course, I was also part of the legal team at the Court of Appeal. And the decision of the tribunal was affirmed by the Court of Appeal, which means that decision that says that the holding of party position does not contravene Section 183 still subsists. That was the decision of the Court of Appeal. Of course, we even cross appeal to say that they did not consider our other objection of saying, look, by virtue of the fourth alteration to the Constitution, the idea of filing petition within 21 days has been taken out of our legal judicial jurisprudence on the election petition, that you should file your petition within 14 days. And we are saying that because that aspect was not considered, the court should look at it, because only the Supreme Court can do what they did yesterday. Only the Supreme Court can just take up a matter on the surface and decide it on preliminary objection without considering the merit of the case. But both the trial tribunal and the Court of Appeal have duties to consider not just the preliminary objections but also the merit of the case. So in their wisdom, they said the other issues have become academic. That was at the Court of Appeal. So we cross appeal on that. And when the matter came up to the Supreme Court, their lordships in their wisdom, 3 of them gave a different interpretation to the provision of Section 183 and the Electoral Act, and 4 of them upheld the decision of the tribunal and Court of Appeal. And like I did say, what was the decision of the tribunal and the Court of Appeal was that the holding of the party position by Alhaji the Secretary Alhaji Malabuni and the Secretary does not contravene the provision of Section 183, and that is still the law. This is the law. A minority judgment remains nothing but a minority judgment. It is of no value. You begin to wonder where people get their interpretation from. Yesterday, I had opportunity of speaking to some of these colleagues, and in fairness to them, they claim that they knew nothing about that. They just based their comments on sentiment and what they had on the social media. Of course, for those of us who practice the profession, we don't practice this on the pages of newspapers or on the television or on the social media. No. We ply our trade in the courtroom. And that is the function of a serious lawyer. You see, a lawyer should not be flippant. A lawyer should be careful, because when you make a statement, it carries a lot of weight. You don't attribute to a judgment what it does not contain. You cannot even read into an act what it does not contain. There's nowhere in the judgment of the majority where the efficacy of the office of our chairman, national chairman, was questioned. Nowhere. As a matter of fact, if anything, what happened was that the judgment of the tribunal that says that the holding of political office, party position, does not contravene Section 183 of the Constitution still stands. And that is the judgment. That was the judgment that was given by the tribunal, that was upheld by the Court of Appeal and upheld by the majority decision of the Supreme Court. I don't know why people are attributing so much to the judgment of the minority. This is of no value.
We're here to conduct the congresses. A lot of people have seen maybe disadvantaged of their position, or being in the disadvantaged position in their community, in their ward. And they want to vent their anger by misinforming the public. All what you are hearing is because of the congresses. I want to assure them the congresses will be fair, be transparent. I want to advise them to go into their ward and be a party man and be a politician. You expect to win, you expect to lose. Then you dust yourself and you re-strategize. It's not to destroy a party by misinforming the general public. At this point in time, on behalf of the caretaker committee, we stand firmly with the national chairman, and we declare our loyalty to him and to the President of the Federal Republic of Nigeria. Our party is strong, resilient, and will continue to do so. This chairman has been able to lift the party from the wood into a skyline that is being recognized all over the world. So we will not dance to the beating of the PDP. We will not be used to bring down the government of the APC.